Good morning, sir. Are you Derek Schenkel?
Yes, ma'am.
And Mr. Schenkel, in cause number 25 DCCR 1797, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. That's from October 15th of 2025. The indictment alleges also that you were previously convicted of possession of a controlled substance, a third-degree felony, October 18th of 2016 in Orange County, Texas. What that means is that if you go to trial in this case and you're found guilty, and if that prior conviction is true, then you would, your punishment would be enhanced from a second degree to a first degree felony with a minimum of 5 years up to 99 years or life in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison. You have every right to reject that and have your case go to a jury and let them decide. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. And do you understand all of that?
Yes, ma'am.
Do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Is there any reason to believe, Mr. Smith, that there would be any change in that offer?
It will never go down, Judge. You got 10 years last time, I only came down to 10. That offer expired today.
So I do want to make sure you understand, Mr. Schenkel, that once your case goes on the trial docket, it's on the trial docket. It's not to buy more time to get a better deal. I will not accept this plea agreement after today. If you change your mind later and want to enter a plea of guilty, it would either be to something either open to the court or to something different than the 10 years. You understand? All right. So I am also going to make the notation on the rejection that I admonished them to the first degree because it was just marked off the second. And so, Mr. Schenkel, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him today and appoint another attorney today who could begin preparation a little quicker. Is that okay with you? So, Mr. Lewis, you're released. Mr. Schenkel, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. Okay, you can go back with the bailiff.
Thank you very much.
All right, so you're Jesse Griffin. And Ms. Coffin, will your client waive the formal reading of the indictment?
Yes, Your Honor, he will.
Mr. Griffin, in cause number 25 DCCR 1397, you're charged with the second degree felony offense of aggravated assault with a deadly weapon from August 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Coffin?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Griffin is not other than what we've already gone through?
No, Your Honor.
All right, so I'm going to find at this time that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Coffin. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Excuse me.
Thank you. Yes, ma'am. Jaden Simon, Mr. LeBlanc.